Well, thank you everyone for coming. Good morning, good afternoon, and good evening, depending on where you're dialing in from. And welcome to the first session of Cornerstone and Mishcon Dere's flagship series, Climate Litigation Lessons from Around the Globe. So we're thrilled to kick off this dynamic exchange and a very timely series by zooming in on our home jurisdiction of Australia. We'll be exploring key climate litigation cases and also the evolving role of courts in addressing climate change. For those just joining, today's session will focus on landmark cases such as Sharma, Pabai Pabai, which to Aussies might be very familiar names. And we'll also be exploring the role of litigation in shaping Australia's climate policy and potentially its extraterritorial effect. And while we don't have a crystal ball, we will try and stipulate or guess as to what might be expected in the coming years. So for some of the audience, this might be the first time dialing into a session specifically focusing on Australia. So for context, when we begin meetings, webinars or other events across the country, we do so by acknowledging country. And this is for non-Aboriginal or Torres Strait Islander people. And when we say country, we don't mean it in the modern sense. And instead, to quote the Australian Institute of Aboriginal and Torres Strait Islander Studies, country is the term often used by Aboriginal peoples to describe the lands, waterways, and seas to which they are connected. The term contains complex ideas around law, place, custom, language, spiritual belief, cultural practices, material sustenance, family, and identity. So wherever you are in Australia, you are on the lands and waters of Australia's First Peoples, but only traditional custodians can speak for or welcome visitors to their homelands. So as I'm dialing in today from Scotland, I will acknowledge the traditional owners of all nations and all lands, and I pay my respects to their cultures, stories, histories, and their special connection to the land, seas, and skies on which we're on. And we encourage all of you to become more familiar with the country that you're on, especially if you're dialing in from Australia or you're visiting now or in the future. So before we begin, just a few housekeeping notes for today's webinar. We encourage you to ask questions. We would love it. Our panel are ready. So please type them into the Q&A box and we'll address as many as possible towards the end. We'd also love for you to share where you're dialing in from. Our panel are all based in Australia, but we understand this is an international audience. So please let us know who you are and what you're doing. So just a quick introduction of our panel. We have Nicole Sommer. Nicole leads the Environment Defenders Office Healthy Environment and Justice Program, working in human rights and environmental justice. Her team of lawyers work across Australia, connecting with communities in 8 locations. Nicole has almost 20 years of legal experience, appearing as counsel in courts and tribunals and advising clients on a broad range of environment protection issues. Nicole sits on the Law Council of Australia's Environment and Planning Law Group, the Board of Disability Voices Tasmania, and holds a Masters of Environmental Management. Stephanie Brenker is a barrister at the Victoria Bar in Australia with a broad civil practice. But before coming to the bar, she was a judge's associate at the High Court of Australia, which is Australia's apex court. She also practiced as a solicitor in London and Tokyo, and she read for a Bachelor of Civil Law at the University of Oxford. And she also holds a JD and Bachelor of Arts from the University of Melbourne. And very relevantly to this panel, she was part of the counsel team in the Sharma case and also its appeal. We have Courtney. Courtney Law is a senior solicitor at Grata Fund, Australia's first specialist non-profit strategic litigation incubator and funder. Courtney has practiced as a human rights lawyer for several years and helps Grata's legal work in developing and supporting strategic litigation across areas of climate justice, human rights, and democracy issues, as well as the organisation's law reform and advocacy work. Courtney previously worked as a civil lawyer and human rights fellow at Legal Aid, and she's also a member of the Law Society of New South Wales Human Rights Committee and Australian Climate Accountability Projects Advisory Group. last but certainly not least is Phoebe Roberts, who is an executive director in the Climate and Sustainability Risk Governance team at Pollination Law. She brings over 10 years' experience as a top-tier corporate lawyer to her practice in climate and nature risk governance and disclosure. Phoebe specialises in embedding net zero commitments and addressing climate change risks and opportunities across commercial contracts and transactions. And in 2023, she was awarded the Law Council of Australia's Young Environmental Lawyer of the Year award in recognition of her leading expertise in this space. So suffice to say, we're in very good hands. So now I will be delighted to hand over to Nicole, who will get us started. So if we could go next slide, we'll just to see so we'll have Nicole, then Stephanie, then Courtney, then Phoebe, and we will then go into the Q&A. So please get those pads ready. And Nicole, over to you. Thank you.
Thank you very much, Lara, for that warm welcome. And I'll start by acknowledging that I'm on Muwinina country today in Lutruwita, Tasmania, the southernmost state of Australia, so almost as close as Antarctica. And I pay my respects to the Palawapakna people of this island and elders past, present and emerging. Today I have the task of giving an overview of climate litigation in an Australian context. Not an easy task, given that we are rated in Australia as the second highest number of climate cases worldwide per country. But I want to thank Cornerstone for this series. It's out to start here, and I'm really grateful for the invitation. I'm now the principal lawyer of the Environmental Defender's Office, and I lead its legal practice, and we are a non-profit public interest law centre specialising in environmental law, working across the Australia Pacific. And a number of the cases that I'll talk about today will be EDO cases. So if you have questions, I'm happy to take them. Today I'm going to, if we can go to the next slide, give a concise overview of climate litigation and a bit of context, because sometimes political context and physical context is really important. I'm then going to look at the emergence of human rights focused litigation with a case study on Waratah Coal, a case run by the EDO in 2022, the first human rights case in Australia, and a little preview of what's ahead, and hopefully that will set us up for a great discussion with the other panellists. So to the next slide. I'm going to spend a little time on the backdrop. So to foreground the conversation, it's important to understand Australia's somewhat unique context. A large part of climate litigation in Australia has been around project-based litigation or decision-making by governments around project-based litigation. And that's because Australia is a major fossil fuel exporter and producer. It ranks one of the highest fossil fuel exporters. In 2022, we were the second ranked for both coal and LNG exports. And in 2021, we were first ranked for both coal and LNG exports. And in 2023, Australia exported 1.15 billion tonnes of carbon dioxide emissions through its coal, LNG and oil exports. So that's part of the backdrop. The second part is that Australia, unlike EU countries and the UK, does not have a human rights framework at the national level. We don't have a human rights charter, and we don't have constitutionally guaranteed human rights. So through this Cornerstone series, you'll probably see a lot of other countries with human rights guaranteed in constitutional law, but not in Australia. There are some implied rights, but it's very limited. And so while we have ratified a number of international conventions, it's a patchy implementation at the domestic level. So that is actually part of the reason why when you're looking at Sharma and you're looking at Pabai and Pabai, that's sort of part of that landscape, and that's really important to know. We do have subnational human rights charters in 3 of the 8 state and territory jurisdictions in Queensland, Victoria, and in the ACT, but that's been relatively recent. Victoria was the starter, and Queensland in 2019, and roughly the same for the ACT. And then the third part, and here is why this slide is relevant, is the backdrop of climate harm playing out in real time. The realisation of climate harms in Australia is the backdrop of the current and future climate litigation that we're seeing in Australia. In 2020, some of you may remember the images of the Black Summer bushfires, which ravaged the entire east coast of Australia, from Queensland down through to Victoria and mainland Australia. I say that as a Tasmanian, which devastated 24.3 million hectares of land, killed over 1 billion native animals. 65,000 people were displaced, and 8,000 semi-permanently displaced, as in their houses were gone, and that meant they had a long time before they had houses rebuilt. 24,000 of those were children, and smoke alone resulted in 400 deaths, according to the Menzies Research Institute here in Tasmania. That's been repeated really with devastating other disaster events, including the 2022 Lismore and southeast Queensland floods. Again, some just incredible scenes and stories on our news. And recently in this year, with a downgraded tropical cyclone Alfred, which landed in Brisbane in the same area as those 2022 floods, and has disrupted the timing of our federal election. But it's disrupted the lives of many, many people. And so that's part of this landscape. So I think that's an important thing to know. And really the drying and the heat across the north and northwest of Australia, the top end, and throughout even the subtemperate rainforests of Tasmania, with many bushfires and different kind of water-based issues, water justice issues emerging. So that's an important thing to know. So we'll go to the next slide. So the early climate cases in Australia were largely project-based challenges, integrating climate considerations into decision-making on projects. The first case was in 1994. It was the Red Bank case taken by Greenpeace Australia against a coal-fired power station in New South Wales. Ultimately, the coal-fired power station was approved, but that was really the first case. The second major case was the case of Gray, a Minister for Planning, taken by a young activist, Peter Gray, against the Anvil Hill coal mine in New South Wales. It was a case that I was involved in, and it was the first case really where we had climate as a mandatory relevant consideration, including Scope 3 emissions of the mine, so the exported emissions of the mine, relevant to that decision through a judicial review process. You can see this is just a small snapshot that one of my team put together, but there's been a proliferation of cases really across New South Wales and Queensland, which are the coal-based states, but including Victoria, WA and the NT, including the Adani mining cases, and the Bulga case, which was about particulate emissions, in particular for residents living near mines. And then we saw with the Paris Agreement, we saw a different wave. So the first case to take the carbon budget to court in Australia was the Gloucester Resources and Minister for Planning case in 2019, taken by Groundswell Gloucester, again another EDO case, against the Rocky Hill coal mine. And in that case, we saw climate evidence led from the late Professor Will Steffen, with the pithy and much quoted line, "You cannot decrease emissions by increasing them." So that was the first case in which the carbon budget was used, and the Chief Justice of the Land and Environment Court ultimately agreed. There were a number of factors in that case, but his decision was, in short, an open-cut coal mine in this part of the Gloucester Valley would be the wrong place at the wrong time. So that was a merits review decision, which means that he made the decision in the public interest, balancing considerations. But that was a landmark case, and the first one dealing with the carbon budget, which you've subsequently seen in other cases, including Sharma and including Waratah Coal. As a result of that case, if we can go to the next slide, and like I say, the backdrop of, say, the 2020 Black Summer bushfires, we see a new wave of climate litigation, which is where we're talking into tonight. And since that time, we've seen more novel approaches to compel decision makers to take account of climate change and act in accordance with the science. And really, this is in the absence of human rights frameworks. You see these novel approaches. So you see tortious claims, including a mandamus case, bushfire survivors for climate action that came out of the Black Summer bushfires against the New South Wales EPA. That's a government framework case. You see the Sharma and the Pabai Pabai case are in that category as well. The corporate and consumer law cases, the World First case of Australian Centre for Corporate Responsibility against Santos Limited, an Australian-based gas producer, for net zero representations and other representations that gas is a clean fuel. This is the first greenwashing case in Australia under Australian consumer law and the Corporations Act. And climate harm cases around human rights. So if we go to the next slide, we'll move to Waratah Coal. I'll just deal with this briefly because I appreciate I'm running out of time. But Waratah Coal was a proposed coal mine, and Youth Verdict is a group of young people who wanted to take action to see that coal mine refused and led a human rights-based climate case. It's a landmark case because it was the first time a human rights was directly pled in relation to climate change. And Youth Verdict argued that the mine should be refused because the coal mine was not compatible with human rights, because it would limit the human rights of all Queenslanders, including the right to life. And the limitation wasn't demonstrably justified, in particular for young people and for First Nations people. Just to go to the next slide. This is a picture of Marawa Johnson, who was the First Nations lead in Youth Verdict, and some of the witnesses. Youth Verdict led a number of witnesses, including First Nations witnesses from Gimuy, Cairns in North Queensland, and Zena Kez in the Torres Strait, Torres Strait, from Two Islands, about the impacts of climate change on them as Queenslanders. To the next slide. One of the really powerful aspects of this case was that we successfully asked the court to adopt a First Nations cultural protocol for taking First Nations evidence, and that meant the evidence was taken on country. And so the court travelled to Gimuy and Cairns and to the Torres Strait to hear evidence firsthand of climate harm. And here are two of the witnesses that the court heard from on country, and these photos were taken on country as part of the hearing. And really the storytelling as part of this case was a really compelling part of these human rights impacts of climate change. So that's one of the key differences in the way that we see that playing out. Next slide, please. And so the court found ultimately that the mine ought to be refused and recommended refusal because the mine and the emissions, the overseas emissions would have a meaningful contribution to the remaining carbon budget, and the climate scenario consistent with a viable mine risks unacceptable climate change impacts to Queensland people and property. There were two compelling parts, which were the findings on the right of the child, and I just think this is a beautiful quote, so I wanted to put this up here. I love this quote: "My generation of decision makers will be long gone, but a child born this year will be 78 years old in 2100. I just think it's such a compelling case. It's really worth reading. And the finding, their best interests are not served by actions that narrow the options for achieving the Paris Agreement temperature goal. This weighs the balance against approving the applications." To the next slide. The findings on First Nations culture were even more compelling, and Her Honour found in particular that sea level rise was an existential threat to Torres Strait Islander people, and that displacement has potential to destroy culture, which is something that cannot be measured in monetary terms. So very compelling findings from compelling evidence, and that storytelling is, I think, what we're going to hear a bit of tonight. So the next slide, and I'll do this very quickly, but where to from here? Well, I think we'll see more climate harm type cases. We have a case this year, which what I'm flagging here for Australian Conservation Foundation, which is around the economic and social costs and climate harms of disasters in the Queensland Land Court. But also, you know, we're going to see more on attribution science as the science develops, and we'll see more people taking action and the leadership, in particular, you know, in the Pacific and from people like in the Torres Strait for their country and their culture. So that's it for me, and I'll hand over to the next speaker. Thanks, Lara.
Thanks, Nicole, and thank you everyone for having me. I'm acknowledging that I'm on Boonwurrung country, which is the southern part of Melbourne, or Naarm, as it's traditionally known. To begin with, I've written the phrase, 8 teenagers and a nun walk into a courtroom. And it sounds like a joke, but actually Sharma and Minister for the Environment was a landmark climate change case in Australia, which I'm privileged to have been a part of. Sharma was the brainchild of Emrys Nekfapil, who's now King's Counsel here in Melbourne, and he was also involved in Waratah Coal, so Nicole will know him. But our legal team, both counsel and our instructors, EGL, became much bigger over time. And I just wanted to give a shout out to all those people because it really was a team effort. What we wanted to do was to use the tort of negligence to stop the proposed development of a coal mine, which had never been done before in Australia and maybe the world. I've been told that some, but not all, of our listeners today will be law students or lawyers. But those of you who are will know that one of the elements you have to prove in a negligence claim is that a person owed a duty to take reasonable care to avoid causing foreseeable harm to another person. There was no established duty of care that applied to what we were thinking of. And so what we had to do to fall within the tort of negligence was to allege a novel duty of care. In Australia, whether or not a novel duty of care is established is determined according to what's called a salient features approach. And that just means there's a non-exhaustive list of factors that the court will go through to determine whether or not to establish a new duty, brand new duty of care. You can't just punch in salient features like a calculator and then out comes a novel duty of care. What we wanted to do was to reason by analogy, and this is very much the difference between the common law approach and the civil law approach that our European listeners will recognise. The common law approach is very much to reason by analogy. Courts will base their decisions on precedents and will follow cases that have gone before them. And if they're going to develop the law, it's going to be very incremental. So we argued that rather than this being a giant change in the law, we were only making a small extension to the development of negligence law. And what that meant was drawing parallels with the Industrial Revolution. So what happened at that point was, for the first time, humans could cause harm on a mass scale. And previously, negligence and nuisance law would be limited to harming your neighbour. And that meant your literal neighbour, the person who was next door to you and had that geographical connection. After the Industrial Revolution, you had trains and you had cars and you had factories that emitted pollution. And suddenly the law had to keep up, and it had to acknowledge that harm could be caused a lot further than just your next door neighbour. So we said, how is climate change any different? And the law should be developed in the same way. What we argued was this was a personal injury case like any other. So the facts. Whitehaven Coal was a big coal mining company, and they owned a coal mine in New South Wales, another state in Australia, and they wanted to extend it to make it even bigger. They had to get approval from the Environment Minister to extend the mine, And when the Environment Minister was approving that application, she had to approve it under an act called the Environment Protection and Biodiversity Conservation Act, or the EPBC Act. We alleged that in exercising her statutory power to approve the coal mine extension, she had to exercise reasonable care to avoid foreseeable harm arising from climate change happening to all Australian children, essentially. And so the applicants were 8 teenagers who were all involved in the school strike for climate movement, and they were represented by a litigation guardian because they were under the age of 18, who was a 90-year-old nun and activist named Sister Bridget Arthur, hence my joke at the beginning. Before the trial judge, Justice Bromberg, the applicants were successful. And Justice Bromberg's judgment was and is the landmark judgment in the tort of negligence with respect to climate change. It just hadn't been done before, and I'll explain what I mean by that. He listed both or went through each of those salient features, those factors, and I won't go through them all because we don't have a lot of time, but he grouped them into positive salient features that supported a duty of care and negative ones that went against a new category of duty of care. And for him, the most important or the weightiest salient feature in support of a duty of care was reasonable foreseeability of harm. In other words, even though this one extension to a coal mine would have a tiny increase in the carbon emissions when you compare it to the whole world and global carbon emissions, even that tiny increase could trigger a world where global temperatures were more than 4 degrees Celsius above pre-industrial levels and could trigger absolutely catastrophic harm. He also considered that matters including vulnerability of the children and the control that the minister had over the harm were factors pointing towards a duty of care. So if I can go to the first slide, similarly to Nicole, this is a quote that is a really wonderful quote, and this is the paragraph that seemed to be taken up by the media after the judgment. The physical environment will be harsher, far more extreme, and devastatingly brutal when angry. As for the human experience, quality of life, opportunities to partake in nature's treasures, the capacity to grow and prosper, all will be greatly diminished. So to me, that really sums up what Justice Bromberg felt was a really important reason to recognise a new duty of care. On the other hand, one of the biggest issues tending the other way is what was called the factor called coherence with the statute. So because the minister was exercising a statutory power, a power under legislation, any duty of care that the common law recognised had to be coherent with the statute and not conflict with it. And that became much more important on the appeal. So on the appeal to the full federal court was successful. So the full federal court overturned Justice Bromberg's decision. 3 judges came to very different views, but to be brief, Chief Justice Alsop, his most important factor out of those salient features was this coherence point and the policy point, which is that approval of a coal mine involves a lot of very high-level core political questions that judges are just unsuited to determine. It's not the role of the courts to be considering matters like Scope 3 emissions, emissions targets, and the weighing of those matters when the minister came to be making her decision. Justice Beach, on the other hand, disagreed with the Chief Justice about policy. He essentially said that the minister was making a positive decision to approve the coal mine. It wasn't as though she was responsible for coming up with how to combat climate change and was making policy decisions. She was making a positive, concrete decision about approving a coal mine. And the focus of the case was, how does that decision, that positive decision, how does that increase the harm that will be suffered by the applicants? However, Justice Beach still found against the existence of a duty of care because he found that the Australian children and the minister didn't have a close enough relationship for the tort of negligence. And finally, Justice Wheelahan had a different take yet again, but I won't go through that. So the takeaway from Sharma: yes, the landmark judgment by Justice Bromberg was overturned on appeal, but the appeal did not close the door on using negligence in climate change litigation. And I would argue to the contrary. The full court, and especially Justice Beach, expressly left it open for a duty of care to exist. Firstly, if the minister approved a coal mine or another project, the operation of which could cause harm to nearby residents, so something that is more geographically close, which I disagree with that it's limited to that, but of course I would, because I was the lawyer for the applicants. But secondly, something especially Justice Beach proposed, one of the issues in the Sharma case is the applicants hadn't suffered harm yet. This was all future looking. And so Justice Beach kept it open that if a person suffered harm from climate change and had a complete cause of action, for example, their home might have been destroyed by bushfire, or they suffered mental harm from climate change anxiety, not that he gave those examples, those are my examples, that might be a different situation. We're not talking about harm that could arise in decades to come. And lastly, this was specific to the EPBC Act. A different act might have different consequences when it comes to that coherence with the statute point. So that's a very, very quick summary of about 500 pages of judgment. And I know it was very legally technical, and I'm sorry for the other half of all the participants who didn't understand that, but happy to explain anything further in the questions.
No, thank you, Stephanie. And I mean, you started with a joke, so it all balanced out. So
we'll now downhill from there.
No, not at all. Just perhaps more technical. Courtney, we'll have you next, and then Phoebe. And just a reminder of the speakers of the 6 to 8 minutes, because we will rapidly run out of time, and we want to have some time for questions. So thank you. Over to you, Courtney.
Thanks so much, Lara. I'm really pleased to be joining you all from Wongal country in Gadi, Sydney today. And I'd like to pay my respects to the Wongal people of the Darug Nation, who are the traditional owners of this land. And in light of what we're discussing today, I'd also like to acknowledge the ceaseless resistance that First Nations people have maintained to protect country and culture, and their leadership in the fight for climate justice, both in Australia and globally. I've been asked to speak briefly today about Grata Fund's work in Australia and the matter of Pabai and the Commonwealth of Australia. I'll do my best to cover this ground in the short time that we have, and also noting that we really want to leave some time for questions. So to start off with, for those unfamiliar with Grata Fund, Grata is Australia's first nonprofit incubator and funder of strategic public interest litigation across 3 main priority areas: climate justice, human rights, and democracy. We've supported almost 50 cases to date, and we work to remove barriers to public interest litigation in several ways. Firstly, by providing adverse cost protection and limited disbursements funding to public interest litigants. And beyond that, by also advocating for reform of the cost system and working to strengthen public and judicial understanding of the importance of public interest litigation in holding power to account and in creating fairer systems and outcomes within a democracy. Grata also leverages integrated campaign and narrative strategies around and alongside litigation, and we do this primarily by providing campaign and communication support to communities who are looking to integrate public interest litigation in wider advocacy and change-making strategies. And that's certainly been the case in the Pabai matter, Fortunately, I won't have a lot of time to delve into that side of things in this session, but very happy to discuss that in more detail at another time. So if I can jump to the next slide, as part of our climate justice work, we are supporting Uncle Pabai Pabai and Uncle Paul Pabai and their communities in their common law negligence class action against the Commonwealth of Australia. Their case was filed in the Federal Court of Australia in 2021, and it seeks to build on the international success of Agenda Foundation's duty of care case in the Netherlands and analogous successful cases seen in other jurisdictions in recent years as well. And of course, building on and standing on the shoulders of many, including those involved in the Sharma matter, who've brought this type of climate litigation in Australia. On our next slide, I've just got a map here to help situate us geographically, particularly for our international audience. You'll see on this map that the Torres Strait is located north of Australia, of the Australian mainland, between the tip of Queensland and Papua New Guinea. Uncle Pabai and Uncle Paul, who you saw on the previous slide, are traditional owners of Boigu Island and Saibai Island, respectively, which are both part of the Gudamalagal Nation, located in the northwestern group of islands there that you can see on the map in Zenadeth-Kez, the Torres Strait. So small low-lying islands, like many of those in the Torres Strait, are currently among the most vulnerable to climate change impacts, as was recognised in the Waratah Coal and Youth Verdict case. These impacts include sea level rise, flooding and coastal erosion, increased average surface temperatures, and ocean acidification and warming. The Torres Strait Islands are currently experiencing sea level rise of around 6 millimetres each year, for example, which is much higher than the rest of Australia and around double the global average. Got some photos here on the next slide. As First Nations peoples, Torres Strait Islanders also have a distinctive ancient customary culture, which is known in their traditional language as island custom, which encapsulates a very unique spiritual and physical connection with their land and marine environment. So beyond property and health, the climate impacts I've just mentioned also pose a particular threat to the ability of Torres Strait Islanders to practice island custom. For example, as you'll see in some of these images, the Torres Strait Islands are subject to regular inundation events, often resulting in the loss of sacred sites. On Boigu Island, for example, Uncle Pabai's Island, a sacred site where ancestors conducted ceremonies is now completely submerged, and a number of cemeteries on islands, including Saibai, Warraba and Masig, have also been impacted by inundation events, which have led to skeletal remains being washed away. And so in their case, Uncle Pabai and Uncle Paul are arguing that the Australian government has a duty of care in tort to protect their people and their islands from climate change caused by the emission of greenhouse gases into the atmosphere. They're asking the court to find two novel duties of care, which Stephanie has very helpfully explained and outlined how that works within Australian tort law. The primary duty is essentially a mitigation duty, which has been framed as a duty to take reasonable steps to protect Torres Strait Islanders, their traditional way of life and marine environment from the impacts of climate change by mitigating global temperature increase through the reduction of emissions in line with the best available science. The second and alternative novel duty that's being argued is an adaptation duty, which has been framed as a duty to take reasonable care to avoid causing property damage, loss of island custom, and injury arising from a failure to adequately coordinate and fund adaptation measures to minimise the impacts of climate change on the islands. For context here, since at least 2001, Torres Strait Islanders have asked the Commonwealth to, among other things, fund adaptation measures such as seawalls to protect the islands from flooding and erosion. Around 10 years later, the Commonwealth approved some stages of that work, but there were ultimately insufficient funds to complete that work. And so now here we are, some 20 years after that funding was first sought, and there are no funds currently in place for the remaining islands, and there are questions about the efficacy of the existing seawalls as well. And so in terms of the outcomes that are being sought, Uncle Pabai and Uncle Paul are seeking declaratory and injunctive relief, as well as damages for loss suffered, including property damage and cultural loss. So jump to the next slide, please. And so Uncle Pabai and Uncle Paul are represented in these proceedings by the amazing team at Phoebe McDonald, which is a specialist class action litigation firm based in Melbourne, and a counsel team led by Fiona McLeod, AOSC, at the Victorian Bar. The trial took place in 3 stages over the last couple of years. In June 2023, the court travelled to Boigu, Saibai and Bardu Islands to hear lay evidence from Torres Strait Islanders on country. You'll see in the photos how the community on each island set up makeshift courtrooms, and the court was also taken to different sites on each island. And this was incredibly significant, as has been alluded to by Nicole and also by Stephanie, that, for lay witnesses to have the opportunity to give evidence about their practice of culture and their experience of climate impacts while on country. In November 2023, expert evidence was then heard at the Federal Court in Melbourne. And in April and May last year, the court travelled up to Cairns in Far North Queensland to hear closing submissions. So throughout the entire proceedings so far, Uncle Pabai and Uncle Paul's communities have been closely following the case, and many attending the on-country hearings on the islands, as well as the closing submissions in Cairns. And beyond the litigation, they're also doing a lot of advocacy work, continuing to build alliances with other climate-affected communities across Australia and the Pacific, and advocating for more ambitious government action on climate. Judgment has been reserved, and we're hoping for a decision this year, so stay tuned. In the last kind of minute or two, I might just briefly touch on a couple of key issues in the case that will be very interesting to see the judicial treatment that they receive in Justice Wigney's forthcoming decision, and will likely have significance for future cases of this nature in Australia. So as Stephanie also talked about, in determining whether novel duties of care exist, the court must consider the special relationship between here the Commonwealth and Torres Strait Islanders and a number of salient features, including, for example, the foreseeability of the harm, the vulnerability of the class, the government's assumption of responsibility, and determinacy. An interesting aspect of the relationship between the Australian government and Torres Strait Islanders is the existence of the Torres Strait Treaty, which is a bilateral treaty between Australia and Papua New Guinea, under which the Australian government has obligations to protect the traditional way of life and marine environment of the Torres Strait. So it will be very interesting to see how this is treated in the court's duty analysis. Another interesting issue is justiciability and the policy/operational distinction that exists in Australian law in tort. In Australian law, this distinction in tort law has been relied on to limit challenges to certain types of climate decisions made by government, which are characterised as policy decisions rather than operational decisions. And so the precise extent of that distinction and any corresponding limitation will likely be addressed in this forthcoming judgment. And in argument in this matter, the plaintiffs were arguing that the relevant policy decision in this context, in the context of Australia's response to climate change, was the decision to become a signatory to and thereby commit to the standards of the Paris Agreement. And having made this policy decision, the Commonwealth committed to setting and implementing its greenhouse gas emission targets in a manner that takes into account the best available science. And so the failures in that framing of the Commonwealth to identify and implement emissions reduction targets consistent with that policy decision are the result of failures at an operational level. So that was how that particular issue was kind of explored in the case, and it would be very interesting to see what that looks like in the decision. And finally, of course, causation is a really significant issue in the judicial treatment of novel duties of care in these types of cases. And so if the court does find that a duty of care exists in tort, as argued by the plaintiffs, this issue of causation, whether increased greenhouse gas emissions as a result of the Commonwealth's failure to reduce its emissions in line with the best available science, caused past harm to the plaintiffs and will cause future harm as well, will likely be a significant aspect of how the court then deals with what the standard of the duty of care was and whether a breach occurred as well. So it'll be very interesting to see how that principle develops more broadly, and particularly looking to the future, what the advancement of attribution science will do to this particular issue in climate litigation as well. So I'll leave it there. Thanks very much, Lara.
Thanks so much, Courtney. You okay for me to just jump in now, Lara? nothing climate lawyers love more than a fast transition. So I will go through my content as quickly as possible so that we can get to all of your questions. But before I begin, I would like to acknowledge and pay my respects to the Wurundjeri Woi-wurrung people and acknowledge their long and uninterrupted connection and care for country that always was and always will be Aboriginal land. I just want to check that I've got my screen showing the slide covering the whole screen. Awesome. So I'm going to pivot a little bit from the discussion so far and bring in a commercial law perspective on the climate litigation ecosystem in Australia, picking up on a few of the themes that Nicole touched on earlier with this new frontier of climate litigation. As Lara mentioned, I'm an executive director at Pollination Law. We're a Band 1 corporate climate law team that sits within Pollination, which is a climate and nature advisory and investment firm. And our work focuses on helping large corporates and financial institutions navigate the legal risks of the transition before they arise. And that is across board advisory, financial reporting, greenwashing, and implementing strategy through tools like corporate contracting. Building on what the others have discussed tonight, I wanted to highlight just two major themes that we're seeing in the corporate advisory space when it comes to climate litigation, and really, from our perspective, what is keeping the Australian director community up at night. The first is the ripple effects of the anti-woke movement out of the US and its impact on climate action. And the second is the surge in greenwashing and misleading disclosure claims, particularly in light of Australia's new comprehensive mandatory climate reporting regime. So there has been a lot of noise about companies stepping back from climate action due to political and market pressures at the moment. And of course, this is not just a US issue. We're hearing the same concerns here in Australia. And we are getting a lot of calls from heads of sustainability and legal teams asking us to brief their boards on why they should stay the course on climate and ESG, even as some companies are winding back their commitments. And many directors are wondering, are we going to get sued for our ambitious targets, for our Net Zero Industry Association memberships under antitrust and competition grounds, as we're seeing in the US? And there's a lot of fear and uncertainty now. And the short answer is that boards need to think about and invest more in the transition now rather than to step back. And that is because the risk landscape has changed dramatically. This old risk calculus where we had this faster transition to net zero would mean lower physical risks, and vice versa no longer holds. As Nicole has pointed out, we now have heightened physical risks, but we now also have a disorderly transition with a much sharper regulatory and market correction required as we barrel towards 2030 and beyond, blowing past the Paris Agreement goals. So for company directors in that context, unfortunately, you can't pick what is a material risk to your business, and your duties under the Corporations Act, which are mirrored on the UK's Company Act, including your duties of due care and diligence, require you to oversee and manage all material risks to your organisation. And we have two seminal legal opinions in Australia that were instructed by our team by leading barristers that affirm this position. So ignoring material climate risks isn't an option. And of course, this applies to nature too, but there's no time to get into that. I will just note that my brilliant Pollination Law colleagues have instructed both a UK and Australian opinion on nature risks as they relate to directors' duties. So it's very short-sighted for companies to limit these risks to the likelihood of being sued or mismanagement of these, and thinking about liability risk just as a litigation risk, because we're seeing an increase in novel and alternative avenues as a flanking strategy to drive action, including a number of shareholder votes against director nominations, against TAPs or climate transition plans, and successful books and records claims, for example, against the Commonwealth Bank. And my final point on this is that we're very much seeing a distinct bifurcation between organisations who have a genuine holistic approach to ESG and climate matters, grounded in those fundamentals of managing financial risks and opportunities to their organisation, and those that have a somewhat performative surface level approach to the climate transition, which makes their commitments easy to wind back, but exposes them, of course, to claims of greenwashing. So greenwashing or misleading and deceptive conduct, as it's known in Australia, is essentially overstating sustainability-related credentials or understating climate-related risks. There's no standalone thou shalt not greenwash law in Australia, but there are very strong misleading disclosure laws, as I've listed on the slide there. For our clients, though, avoiding greenwashing isn't just about compliance. It's about ensuring that capital flows to genuine sustainability-aligned products and services. Greenwashing distorts the market, making it harder for investors and consumers to direct capital towards real transition efforts. So for companies genuinely investing in the transition, competitors engaging in greenwashing undercuts those investments. And this is why it's not just regulators and strategic litigants who are enforcing these laws. Corporates themselves have an interest in preventing greenwashing. And Australia is ripe for greenwashing claims across these 4 main contexts that we have on the slide there. And that is because our misleading disclosure laws are very plaintiff friendly and the threshold for liability is much lower than in many other jurisdictions. And the first reason for that is that the person doesn't actually have to be misled. It's enough that there is a real or sensible possibility that a reasonable person in the audience would be led into error by the impression conveyed. The test is based on an ordinary and reasonable person in the audience, and this is generally pretty low. So ask yourself what your great aunt Joan might understand carbon neutral or offsetting to mean. Climate claims are generally very technical in nature. So this is a very key area of risk that we're seeing. There is no need to demonstrate intent to mislead. You can have acted both honestly and reasonably in making a relevant statement or omission and still get exposed to liability. And there is no need to prove loss or damage, though this affects the remedies that are sought. And finally, in my whip through of Australian misleading deceptive conduct laws, there are special rules for forward-looking statements. There's no specific safe harbours in the Australian regime. And the rules for forward-looking statements, and this applies to, in this context, think targets, think transition plans, that they will be deemed misleading if at the time they are made, there were not reasonable grounds for making them. So there is an evidentiary burden on the party making a representation, so it flips to demonstrate that they have reasonable grounds. So the rule is not that you need to have a crystal ball. You don't need to be correct or right and see to the future, but you do need to have reasonable grounds at the time for making the statement. And the penalties are quite sizable, but I won't go through those. You can look them up in your spare time. The second point is that greenwashing claims work, and in Australia, our very well-funded regulators are prioritising enforcement. ASIC has, and I should say well-funded compared to other jurisdictions, but ASIC has already won 3 greenwashing court actions with penalties exceeding 10.5 million per case and has initiated 82 greenwashing interventions since 2022. Strategic litigants are also using greenwashing claims to drive corporate action, and they're targeting very large companies like Qantas. There's been a recent claim against Qantas, Energy Australia, Woodside and Santos, which Nicole mentioned earlier, which is a landmark case that we're expecting the decision very soon, being led by the EDO. So the third reason why Australia is right for greenwashing claims is we're about to have a significant uplift in the sustainability-related information in our market through our mandatory climate-related reporting regime, which is aligned with the ISSB framework. There is a modified liability regime for the first 3 years, which means that only the regulator can bring claims, but it is creating a lot of anxiety for companies worried about greenwashing claims. The modified liability regime only applies to the statements in the sustainability report. So if you're repeating anything outside of your report in other contexts, those modified liability regime does not apply. The point I'd like to just leave you on is a bit of an interesting conundrum on greenwashing, which is that companies are caught in a tension. Those who want to take real climate action but are afraid of being sued because of the risk environment that they find themselves in may feel discouraged from disclosing their sustainability effort. Meanwhile, investors and consumers are asking for and need accurate information to differentiate genuine action from greenwashing, which really underscores the need for sessions like this, and for continued education on how to prevent greenwashing, even unintentionally, to ensure that companies and market participants can communicate their sustainability credentials with confidence and helping to accelerate the transition. So I will leave it there, and we've got 2 whole minutes for questions, everybody.
Phoebe, thank you so much, and thank you everyone. And for those online, we can go over. I'm told the Zoom will not shut off on the hour, so if you can stick around, please do. We've received a number of questions in the chat, so I'll start with one from Dr. Joanna Setzer around the response to Sharma. And I think this goes more broadly to the question of, implementation and reverberation in the Australian landscape once litigation is brought. So her question is, after the Sharma case, there was an effort to pass a duty of care bill. Can you talk more about this legislative effort, and perhaps also, and this is to the panelists, perhaps forecast as well, like the imminent election that we're seeing and what it's like on the ground at the moment. So I think, Phoebe, you were going to start off, but please.
Yeah, and Stephanie, jump in as well. You might be closer to this than me, having been involved in the case, but I can talk a little bit about the process and where the bill is at. So it was introduced last year by Independent Senator David Pocock, and it really was aimed at filling a legislative gap following the Sharma, a perceived legislative gap, I should say, from the Sharma decision. And last year, and really to enshrine that duty of care and intergenerational equity bill, to enshrine that in law following the decision and the overturning of the original Bromberg decision in Sharma. There was a Labor-chaired Senate committee last year, in the middle of last year, which recommended against the passage of that bill. But it's not dead yet. So this year there's been a really renewed demand for the bill and to kind of bring it back to life, driven by Anjali Sharma, the lead plaintiff in the case, and a group of young people. And this year they've written a letter to the Prime Minister. They've had a lot of influential Australians signing this letter to revive the bill, particularly bringing it to the attention before the upcoming election that hopefully will be called soon.
Perfect. Will, is it possible to stop? Oh, Phoebe, stop sharing the slides just so that we can see all of us on the screen. Fabulous. Any other comments on legislative responses, or more generally to the question of, what's the next frontier in litigation and what we're going to see in legislation and also in the courts? Just a simple question to respond to. Feel free to unmute and dive in, team.
I think, I'm not sure if it's Pabi or Pabai, but that was one very clear example of finding that Sharma did not close all of the doors to a negligence approach. But other than that one case, I haven't been made aware of many others. So I'm hoping there hasn't been a chilling effect by the overturning of Sharma, because, as I said, I think there are lots of really helpful things in not only the first instance judgment, but also in the appeal judgments. And Anne Sharma, who worked with David Pocock to create that duty of care bill, she is a force of nature, and I can see why, following especially Chief Justice Alsop's decision that focused so much on the policy, courts are not getting involved approach, that they would go to the legislature. But I think that Australia is still ripe for some creative solutions.
Great. Just looking, we've received some specific questions around the Sharma case, which Stephanie is answering live, which is
I'm typing.
much
and,
appreciated.
yeah. And also thinking deeply, because they are interesting questions.
Yeah. In terms of the evolution of climate litigation case theory in Australia, what would you want our overseas listeners to take away? If for nothing else, I know we've thrown a lot of information at them in a short period of time. What would be the one thing you'd want them to remember from this webinar?
I'll do one more then. I just think that the great thing about this panel, Lara, that you've put together is the complete diversity of approaches to climate change remedies in Australia. And, you know, obviously, as Courtney was saying, that part of it stems from the fact we don't have a Bill of Rights, but climate change is being attacked not only through, you know, administrative law, judicial review, which is a huge part of this Australian climate change landscape, through politics, through tort and the common law, through greenwashing. You know, like, I think we've just got to keep attacking it from every angle and throw everything at it till something sticks. What other choice do we have?
I think to that point as well, just the value of collaboration with international colleagues, given the nature of the issue that we're dealing with, is so valuable. And I think as well, something that we're seeing in Australia in the current political climate are also threats to climate litigation and the feasibility of that moving forward, and people being able to bring litigation, without fear of kind of retribution and that type of thing. And so I think actually creating a culture in which we understand the importance of the courts and, you know, public interest litigation when it comes to addressing climate change, and doing that advocacy around that as well, because, you know, we're seeing, I guess, the flip side of positive potential legislative intervention is also negative legislative intervention. When we're seeing in certain states and territories in Australia, you know, new legislation or threats of legislation that are closing off certain litigation pathways when it comes to merits review, for example, of environmental decisions. And so kind of taking a really creative approach to different pathways and collaborating with one another is just so important.
I'm going to jump in there. Courtney, I think you just said all of the things I would have said, but I think probably for me, it's everybody needs to understand the climate science. The science is getting better all the time. And it's actually every lawyer's obligation to be advising their clients on the facts. I think Phoebe makes this point really well, but that goes for anyone, you know, in any capacity in the system. I think most of these cases are simply trying to get decisions made according to the facts and according to the best available evidence, and we have really good evidence. The second thing for me is the power of people. The reason why these cases are so powerful is because of the really powerful and incredible clients that each of us have had to bring these cases. And the reason they're powerful is because they're just talking about human experience. So human rights for lawyers can be quite a theoretical concept, but if you've lived a climate disaster, you know, I think one of our clients, Bushfire Survivors for Climate Change, Joe Dodds says, I'm doing this so that nobody else has to go through it. You know, that's the sort of approach that Australians are taking, and I think we'll see. One of the things that I'm really excited about is the leadership in the Pacific, because the Pacific, our neighbours in the Pacific are at the really front end of climate change, and we saw that in the ICJ hearings. So get informed and back in community rights, because like people power is the most important thing.
how do I follow up on that, Nicole? But I think I would just add, Courtney, I was pondering on the exact points that you raised. It's really, I think, disheartening to hear about these challenges to climate litigation, but it does add a little bit of fuel to the fire that it must be working if the opponents to it are trying to stop it from happening. So I do think that, yes, climate litigation has had these amazing incremental impacts. And we talked about that earlier on the panel, these incremental impacts. But I do still believe that there is a black swan climate litigation event happening, building on these epic cases that we've already had, like Waratah, bushfire survivors, that have paved the way for change in Australia, that Australia is really leading the way in novel climate cases, and that really it impacts on every area and practice of law. I know we've got a really diverse set of lawyers practicing in all different areas joining in today, and I think the Victorian bar that Stephanie is a member of has produce a report that's a review of Australian litigation across different practice areas. And so even just pick that up to see how climate change is impacting on your area of practice, and I guarantee you that it will be. So that is all I will say. So thanks, everyone. It's been a really brilliant panel, and thanks for the questions.
Thank you so much for all of you. And one thing we haven't touched on, but I'll briefly put in as well, is Australia's response in their bid to host COP31, and whether or not that will have any trickle-down effect into domestic policy. But I guess we've got an election coming very soon, and that will give us a better idea of what the next 3 to 4 years in Australia will look like, whether there's more or less ambition on climate. I can see we've got a question on Waratah coal, but with almost 10 minutes out, I'm sorry that we have to close. But before we do, I just want to thank our hosts, Cornerstone Chambers, and specifically Estelle Dehaun, Nina Pinham, our wonderful Will, who's done the tech support, also to Dr. Joanna Setzer as well, and Mishcon Dorea for their support in this series. And of course, to each of our 4 panelists, it's been a joy to have you all convene, and like a real highlight for me. So thank you so much. And to the audience, if you do have any questions, get in touch via the Cornerstone email. They can forward it to us. We're very happy to continue this conversation, because as we know, it's not going to get any better. So we've got to roll our sleeves up and do what we can. Thanks, everyone. Have a great evening, great day, and we'll chat soon. Bye.